Welcome back to Between Two FARS. I'm Warneke Miller here once again with Michael Mark and Robert Tepfer, two of our titans of procurement law here at NASA. And we are continuing to talk about litigation in front of the Armed Services Contract Appeals, the ASBCA. Now, I bet anybody who has litigation in front of the ASBCA has heard the term Rule 4 file. Well, that's what we're going to start talking about today. Gentlemen, what is a Rule 4 file?
Well, as the name implies, it's based on Rule 4 of the board's rules of procedure. And it's essentially the contract file. It's what the government has on the contract at the time that the appeal was filed. So it's got the contract, it has a lot of the internal documents, you know, the inspection reports, the exchanges between the contractor and the government, the financing stuff, the claim will be in there. So it's basically the government contracts file, and that becomes the basis of the beginning of the case and lays the groundwork for further evidentiary submissions and discovery.
Now, I know we talked a little bit about
30 days.
Yeah, we talked a little bit about the flexibility of the timelines and being able to negotiate with opposing counsel and the board. But technically, you're supposed to get all this stuff together within 30 days?
Yeah, well, that realistically, on really big cases, that's just not going to happen, and it would be absurd to demand that. I had a case once with 15 million documents, and you had a litigation support contractor putting it together and trying to go through and find all the relevant documents. We effectively embraced what we call rolling discovery response. And I think the first, after 30 days, we in good faith, we had like 69 binders put together, and that was just the beginning. And
is that rolling discovery this supplemented at times that are fair and reasonable by the board? Is this those supplemental filings you're talking about?
Well, no, this was actually the initial submission, because if you can imagine a contract that had gone on for 10 to 15 years, there was a lot of correspondence and a pattern there that we needed to get into evidence. And we didn't have any problem from either the board or opposing counsel, because they wanted it all, and they realized logistically it was going to be painful. And they also knew that they were next up to bat, and any kind of unreasonable demand would be something that they would have to live with as well. Plus, it became kind of a situation of they really couldn't look at more than 69 volumes in a meaningful fashion. So it worked out for them as well.
So their duty here under Section 4B to file within 30 days of our filing was kind of delayed a little bit because you had this rolling deadline.
We rolled through it, and then they could come back and they put in theirs, and we obviously had a lot more documents than they did, because we had created the item that had caused, in their mind at least, the problem, and so they gave us more time. But both parties are very cognizant of the fact that there's a supplemental Rule 4 file that is ultimately created, and the documents that are in fact obtained during discovery from both sides are used to supplement that file. Consistent with the scheduling order that the judge puts out, and then objections are made after a reasonable time, hopefully, is provided to review those documents.
Yeah, let's talk a little bit about those documents and how they play a role and whether or not you have to authenticate them. I know Section 4C starts talking about the organization of the file. Let's put off talking about that for now, but talk a little bit about how these documents in the Rule 4 file are used and their importance in this litigation.
Well, they are the basis of the case, and one of the important things is you don't have to authenticate the documents that are going into the Rule 4 file, and they go into the Rule 4 file and they stay in the Rule 4 file unless somebody objects to them being there. So that's one of the things the appellant is going to do, is go through and see if there are things that they think shouldn't be in there. They're going to have to object. Similarly, if they start submitting things, they're going to come in unless we object. So it's sort of the opposite of what you see in litigation in a court, where you have to offer the evidence and get it admitted, and you don't object to it after it's already been admitted, in board litigation, it's already basically part of the record, and you have to object to get it out.
One of the things that, you've got a case you're building all along, you're effectively doing interrogatories, you're doing scheduling for deposition, your request for admissions, you're trying to figure out what are the documents you want. At the same time, you have to be reviewing whatever has been submitted, and hopefully on the side, you're putting together those objections, because, well, at the end of the case, you're going to be doing all these things. There's going to be a scheduling date where the objections have to be made, and you don't want to forget what was significant or only dwell on the last few documents that they put in there because you hadn't been thinking about it because you've been working on a particular aspect of the case.
Mm-hmm.
A lot of different aspects to keep in mind all at the same time, huh? A lot of these deadlines seem like they're sort of on top of each other. You're going through the complaint, you're getting your witnesses together, you're preparing your answer, you're putting together the Rule 4 file. All these things are simultaneously occurring, right?
Yeah, it's like a springing program office where you all of a sudden you have like maybe 3 to 4 attorneys involved and you assign them. Your job is to figure out what documents we need. You are going to put together interrogatories. You're going to examine the documents let me know what they are, and write down any specific objections on them.
Right. It is a team effort, and it's not just the lawyers, it's also the program people. They need to look at this stuff and make sure, okay, is it right? What is this? Tell me what this is. The contractor put it in. We haven't seen it before. What is it? So we need help on that. There are technical documents, and we're not engineers, we're not scientists, so we're going to need some help understanding a lot of what's going in there.
There's a lot of cases in the context of accounting where you really cannot work a deposition or put together a response, perhaps even in the answer, without having the accountant sit next to you or assist in the document request or telling you what documents need to go into the Rule 4. Those types of skills, we don't have, and we need to have that advice early on so that we can focus the case and make it as meaningful as possible, right from the inception, and the answer in the Rule 4 to support it and honor what we request.
Yeah, accounting and scheduling is the other one. Critical path methodology, that's something you definitely want an expert on that.
So the Rule 4 file is an important aspect of your case. It's not just the foundational evidence of your case. It is the evidence in your case. Join us again next time, Between Two FARS.